21-147-838. This is Preferred Rehab Care versus City of Detroit. It looks like the matter is before the court for a review. Your appearance for Preferred Rehab, please.
Good morning, Your Honor. Sharif Arif, appearing on behalf of plaintiff P74522.
Thank you, and good morning to you, sir, and for the City of Detroit, if you will.
Good morning, Your Honor. Joel Ashton, appearing for the defendant, P number 47039.
Good morning to you, Mr. Ashton. Looks like I don't have a complete file here, so somebody go ahead and update me. I know I adjourned for review.
Sure. So this case is settled. I would like to, if possible, get this settlement on the record. And then if this court would be so inclined, maybe you can give us 30 days to submit closing paperwork.
You said, yeah, closing paperwork sounds good to me. And one of the things, that I typically do is issue an order that closes things out. Of course, with the right of the parties to come back unless there's something, if there's something crazy that takes place. But go right ahead and we'll figure that out at the end.
Okay, so did you want me to put the settlement on the record now?
That's okay with Mr.
Okay.
Ashton.
Okay.
All right.
So please let the record reflect that this matter has settled for a total of $8,854. $8,854 is a settlement. And this closes the case, and hopefully we will get the court its closing paperwork that is needed within 30 days.
Mr. Ashton, is that in fact a complete statement of the settlement resolution in this matter?
It is, Your Honor, though it's important to note that this is at this point a tentative settlement, which does need to be approved by City Council. So I would just add to the terms of the settlement that our agreement is conditioned upon that approval. We'll make every attempt to see if we can have this done in that 30-day time period. But as the court knows, we're at the mercy of the agenda of the City Council. So I would anticipate this would be finalized probably in a 30 to 60-day time period, but I can't commit to any specific time period.
It sounds like there is indeed a settlement. I'm going to go ahead and issue the order that I would typically issue, and it is an order that says that the parties in good faith have indicated that they've reached an agreement, that agreement is subject to approval by a governmental board, which the parties reasonably anticipate will not be a problem, and that once that is approved, that approved and the payment issued, the dismissal at this time would be a final dismissal with prejudice. So it is a dismissal pending final approval. That will close the case out. It has in the language of it the right to come back if for some reason one of those two contingencies fail. That is a City Council approval, and number two, issuance of the actual payment. So that's what I'm going to issue, and therefore I won't set any other date. You'll get that order from the closing matter out.
Thank you.
All right, thank you. Good day to the two of you.
Thank you. Have a good day.
Thank you.
Okay, Jeremy. Okay, thank you.
Right, the court now calls case number 21-52689. This is Spine Health PLLC versus New Horizon Chiropractic and versus strike that is and New Horizon Chiropractic PLLC versus City of Detroit. All right, your appearance regarding this matter looks like it's set for review on today's date. For the plaintiff.
Your Honor, this is Philip Hiltner, P77913 for defendant. I've been in touch with plaintiff's counsel's office this morning, and I don't believe anybody will be appearing. But we've settled the case. They confirmed that they even received the settlement checks. So all the paperwork is done, when we'll be submitting an order to your court dismissing the case.
All right, how soon you think your order's gonna get here?
It will be in the mail today or tomorrow. And I've already received confirmation. I can sign their name, submit the order. It's just a matter of how long it takes for the mail to get there.
All right, well, go ahead and do that. I'm likely going to issue an order today indicating that the case is settled and that the payments have been issued, the case should be dismissed or is dismissed. So I'll note that on my file, and you may very well get an order in that regard. You send another one, I'll sign that one as well.
Okay, I appreciate it. Thank you, Your Honor.
Good day. The court now calls case number 21-164-937. This is Andrea Wilson versus Nationwide Mutual Fire Insurance. Minutes before the court set on, looks like for the pretrial conference. I know that the court issued a previous scheduling order in this matter, and then at the end of that order, it was adjourned a bit further until today's date. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Helen Cooley on behalf of plaintiff, P number 84581.
Good morning, counsel. And your appearance for Nationwide, please.
Good morning, Your Honor. Catherine Rohde, P83529 for Attorney of Record Jeffrey Peach on behalf of the defendant Nationwide.
All right, thank you, Ms. Rowley, and good morning to you. Ms. Goldie, I think it's going to be you updating me on what the status of things are here, please.
Yeah, Your Honor, we recently sent discovery response to the defense and also some signed authorizations. We also had the depositions of our the client and the provider. We're just waiting on getting things together with defense, and hopefully we can wrap this up.
All right, so basically, it looks like you're tying up some loose ends to see where the conclusion or where the finish line might be. Is that on the sides of?
Yes, Your Honor. If I may, the deposition of the care provider is actually scheduled for this week on April 25th.
Okay. All right, good. So it looks like you'd have a better view of what this case looks like in about 30 days or so. What do you think, Ms. Rowley?
Yes, Your Honor. I believe if we could just have an adjournment of this case, 30 days would be fine if the court's preferable to that.
Ms. Coley, that enough for you?
I think that's a good time, Your Honor. Hopefully we can get this wrap up.
All right. Okay, so we'll at least review it at that time. So I'll go ahead and set it over for the 23rd of May. That's 5/23/22. And that's going to be at 9:30 a.m. 5/23/22 at 9:30 a.m. You'll get a notice regarding that date. The matter is adjourned. The court finds good cause for the same, and the court will take the matter as a pretrial review on that date.
Thank you, Your Honor.
Thank you, Your Honor.
Good day to the two of you.
You too. Thank you.
There you go. Diana said, the eyeglass lady said, when is a good time to call it?
They have to. I'm trying to get home. We gotta get over there.
Maybe, okay, okay. Yes, sir.
My teeth are so spoiled. You doing a typing too, Judge? Oh, right
You
now?
know, I want to, once that finish line, I want to push it to the finish line.
All right, okay.
You know how we do.
Yes, sir. All right.
Finish line.
Touch it only once.
That's
Can you train some of the other ones, Judge?
what goes with that.
This one here? Okay, all right. Yes, sir. All right.
Take it.
It's okay. It's okay. You sure did. You sure did. No, it's okay. Okay.
All right, we are on the record in case number 21-154-940. This is Affiliated Diagnostic Coleman versus the City of Detroit. The matter set for review on today's date. Your appearance for Affiliated, please.
Good morning, Your Honor. James Lowe on behalf of the plaintiff. My P number is 63110.
Thank you, Mr. Lowe, and good morning to you, sir.
Thank you. Good morning.
Good morning, Your Honor. Gregory Pattison, P 75963, here on behalf of the defendant, City of Detroit.
All right, thank you, Ms. Patterson, and good morning as well to you. All right, so where are we? I know that I adjourned it a couple of times. It seems that there was at one point some discovery issues, and then there was some attempts to try to get this resolved. So somebody update me, if you will.
Yes, Your Honor. I believe there is still outstanding a motion to compel. It relates specifically to 3 interrogatories that were sent as part of supplemental discovery requests. The long and short is that we were inquiring into common ownership of other businesses by Affiliated Diagnostics, corporate officers, other instances in which Affiliated Diagnostics has treated plaintiffs that were involved in hit and run incidents, and then any individuals that have been compensated regardless of form by Affiliated Diagnostics over the last 5 years. Plaintiff sent us their response to the motion, and in their objection or in their responses effectively argued that it exceeded the scope of allowable discovery under the No Fault Act, relying on Watson versus State Farm Mutual, actually an Eastern District of Michigan case. However, Your Honor, if you do recall, this is a accident that we played the video in which a vehicle traveling behind the bus, in my estimation, appears to intentionally nudge the rear of the bus on a couple of occasions. And this would represent one of 16 hit and run accidents with relatively minor or inconsequential contact, which we believe is part of a larger fraudulent no fault scheme. And as outlined in the Watson case, there are exceptions to the discovery limitations of MCL 500, 3158, and 3159, where there's a showing of good cause. In this instance, we take the position that presenting that this is part of a fraudulent insurance scheme is fundamental to our defense of this case, and believe that good cause exists to compel plaintiff to respond to the 3 interrogatories I outlined earlier.
It sounds like Mr. Patterson's arguing his motion, which, and we can certainly do. I thought today was a review, but we are just a diagnostic testing facility. We certainly can't control. We just get prescriptions and we do MRIs based on those prescriptions. The Watson case says that the ownership interests of our business is not discoverable. We believe this is for purpose harassment. This is a conspiracy theory driven by attorney argument. The fact is that Mr. Patterson said that there were something like 16 hit and run accidents that the city of Detroit had. And they believe that somehow a diagnostic testing facility who has no control over who shows up at their door with a prescription just does MRIs for that. And the interrogatory about identifying all the patients who they provided who were involved in hit and run accidents. My client wouldn't keep track of that. We don't keep track of who we treat or in what types of accidents. That just doesn't make any sense. Nor would a pharmacy keep track of that either. It's not, and every employee, every person that's received any type of compensation of any type for the last 5 years, I'm not sure how that's relevant. It's looking for essentially every independent contractor, every employee that's ever touched my client within the last 5 years, or if we're looking deeper, if I'm following Mr. Patterson down the rabbit hole, then he's looking for payoffs to people, some sort of. It's essentially we're litigating. Mr. Patterson's looking to litigate a RICO case in a simple district court case, and now, what used to be the standard for discovery was what's calculated to lead to admissible evidence. But as we all know, the court rules changed in 2020. And there's a scope of discovery is different now. The scope of discovery, if you look at 2.302 B5 or B1, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claims and defenses and proportional to the needs of the case, taking into account all pertinent factors, including whether the burden or expense of the proposed discovery outweighs its likely benefit, the complexity of the case, the importance of the issues at stake in the action, the amount in controversy, and the party's resources and access to the relevant information. Information within the scope of discovery need not be admissible and evidence be discoverable. What the takeaway from that is that discovery used to be very broad, and now the court needs to weigh proportionality here. And in a simple district court case, I don't believe that this is a forum for the city of Detroit to litigate a RICO case or do discovery for a RICO case. There are certainly much bigger, better cases that they could do that. And if they want to file some sort of RICO action in a federal court, then they're certainly entitled to do so. But I think this is so far out left field from discovery in this small district court case.
Briefly, Your Honor. Well, first and foremost, it's very well established that there are instances of acts of fraud which cut off no-fault claims. So the existence of fraud is certainly relevant to the defense. To the notion that this is a diagnostics entity that simply is sent patients with prescriptions, well, there goes the question about any common or mutual ownership or interest in other entities. We've seen a number of cases where an individual will have either themselves directly or through familial associations, ownership interests in an MRI company, a transportation company, a pharmacy that simply cycles these patients to each of these companies. And those questions are not particularly difficult. The owners and the officers of affiliated diagnostics, hey, what other businesses do you have an ownership interest in, or an officer's position with? As far as the payments, we can certainly agree to a protective order in that respect. But yes, we have an opportunity to look and see if these entities are using runners or spotters to solicit accident quote unquote victims, and I use that term loosely in the context of this case. So those are fundamental to our fraud defense in this case. And Mr. Lowe was correct to some extent. This is a little bit of a conspiracy theory, but in this unique circumstance, this conspiracy theory is supported by video that I think very clearly shows a vehicle intentionally striking the City of Detroit bus on which Mr. Preston was apparently riding.
Hi, well, it sounds like, Mr. Patterson, it does sound like you do a little bit of placing inferences on top of inferences to justify some discovery requests that are quite broad. Obviously, when you place the term fraud into it, then of course that does kind of raise the ears and the brow, if you will, of court and everybody concerned should do that. But the questions that are posed here are certainly beyond one of the key things I was thinking about was proportionality. They seem to smack of placing an inference upon an inference to try and get to a conclusion that, given that someone on a bus may have participated in a setup to bring a case, that it somehow means that any entity that they interface with, that those entities are implicated as well. I think that you certainly may discover questions of information that is more narrowly drawn. And certainly, if you asked of the various persons who are involved of the entity, if they have any connections to any other entities, and what is the nature of those connections, and you specify the entities that you're talking about, and you raise the question about whether or not they have runners, do they have persons that are seeking after cases, that they have people on hire. You can ask specific questions like that, but a question that requires a specific disclosure of all of the business operations and all of the connections to any patients that an entity has had because of the fact that they treated a particular person. That's a bit much. The discovery rules would not allow that. I know that there is a bit of a catch-all that says that, well, yeah, if you got fraud, then maybe you can drill down on some deeper information. And I think that to the extent that you have a predicate as relates to affiliated diagnostics as a fraudulent operation or indicia of the same, then perhaps you could drill down on that issue. But I don't think that you've developed that issue well enough to be allowed to ask the far-reaching questions that expand the elasticity of the discovery rules at this point. For that reason, I will deny the motion to compel with regard to the various questions that have been set forth before the court. That does not preclude Mr. Patterson from drawing the questions more narrowly. These questions are much too broad and too far-reaching in the context of this case, and only one of the issues is proportionality, but that is a significant issue. I'm really concerned about the fact that there is an individual, or maybe some individuals, that have filed lawsuits, some 16 lawsuits, only one is in front of me, that there's a thought that maybe this entity somehow has something to do with the behavior that these persons may engage in, presuming that that behavior is something that that may have some illegality to it. Well, connecting those dots have not been done here. I mean, you can't really say, well, let me go fishing for it and then we'll figure it out later on. That's, I wouldn't allow that, and so I'll deny the motion for motion to compel at this time. And again, I think I made it pretty clear that I do think that there are some questions that you might be able to ask them to discover some information. Not these questions; they're much too broad and far. So the motion is denied.
Thank you, Your Honor.
Thank you, Your Honor.
All right, so looks like, so where do we go from here? Are you talking about some type of resolution, or just give a little bit more time to drill down on perhaps discovering some additional items?
Your Honor, this is, I believe, the final pretrial. I have on notice is the final pretrial as well as a hearing on the motion to compel is what is in my notes here. I don't know if that's coincides with what's in the courts. I don't believe we've had any settlement discussions at this point. I'm certainly not opposed to that. But from a posturing standpoint, that's where we're at.
Sure. I don't think that before we got past today's motion, I don't think it was going to be fruitful to even talk about him. If Mr. Patterson needs more time, given the court's ruling, then that's certainly fine with me. I'm certainly open to settlement discussions as well.
All right, so what I'll do, gentlemen, is I will bring the case back in the short term with anticipation of setting it on for trial. Parties are not finding some traction in terms of getting it resolved and or drilling down on some further discovery. In light of the court's ruling, I've made it clear that the door is open to some for follow-up questions that are not as broad as the questions that were raised in the that gave rise to the motion. So I'm going to go ahead and set it 30 days out. That's going to be May 23rd, 2022. And I'm going to set that for 9:45 on that date. I'm going to set it for a review. And as I indicated, if you are moving towards settlement, or if there's some other discovery stuff that is being exchanged, and we'll see where to go from there. If there seems to be an impasse, then I'll set it for trial on that date.
That makes sense, Your Honor. Thank you.
Thank you,
All right,
Your Honor.
gentlemen. Thank you. Good day to you.
Yep.
Thank you.
Take care, Your Honor.
Take care.